Okay, good morning. I'm Elizabeth Smith. I'm the Research Director here at Business Forums International, but I think most of you know that by now. I hope you're all well and welcome to the 17th What to Do this week, where we'll be looking at data protection challenges for employers that are posed by COVID-19, as if you didn't have enough on your plates already. Today, we'll be looking at record keeping, policy updates and changes, the implications of workplace testing, then a look at home working and the legal framework and guidance that you need to be aware of. And as always, our panel today have both knowledge and expertise in this area. So I very much hope that you will hear solutions that will work for you and that your questions will be answered. Do post questions as we go along in the usual place, Q&A or chat, and I will make sure that they are addressed to the relevant expert. And the webinar will be recorded, so that's going to be available to you afterwards if you have any unexpected interruptions, which is one of my very favourite parts of working from home. And all today's handouts and downloads will be sent out to you afterwards, so that's quite a valuable email to look out for. Our first speaker today is a very old friend of BFI and someone we've been lucky enough to work with for longer than either of us will admit. Dan Cooper is with Covington. If I could ask you to put your mic and camera on, Dan. And he advises clients on information technology and regulatory issues, particularly data protection, e-commerce and data security matters. Welcome, Dan.
Yeah, pleasure to be here.
Dan has worked with leading technology companies, including social networking sites on European and global compliance strategies. And he has experience with the regulation of mobile and e-health technologies, as well as co-authoring data protection standard that governs organised sport. He has been appointed to the advisory and expert boards of privacy NGOs and agencies such as Privacy International and the European Security Agency, ENISA. I think that's quite enough of a build-up for you, Dan. Today, Dan and I are going to be talking about the implications of COVID for data protection. Can we start with privacy notices and policy changes? What should employers be thinking about right now?
Sure. I mean, one of the impacts of COVID is that companies are now collecting different types of information than they formerly would have collected.
Mm-hmm.
This can run the spectrum of health surveys or questionnaires before employees return to work. It can involve actual temperature testing when they're arriving at work or things of that sort, contact tracing as well. The basic principles of UK and European data protection laws that you provide adequate disclosures about the data you collect. And I think for a lot of organizations, it'll probably force them to develop bespoke notices to inform individuals about what information they plan to collect or will collect, as well as maybe changing internal policies about how they handle that information. So for instance, I don't expect many companies have policies, well, pre-COVID, which would have referred to the fact that employees may need to submit health information in order to get access to the work premises, or that they may collect information about their whereabouts while on premises to do contact tracing if they become unwell. So that would need to be thought through, and you may need to have to develop bespoke notices that might appear in the hallways as people are entering a building, or presented to them in other ways. The same would apply to customers too. People listening today may operate businesses where customers come on site or contractors. Same problem gets presented there. And then, as I said, internally, you may have to think about your internal policies for dealing with personal data, because they may need now to be changed because of the new nature of the data that you're acquiring.
So specifically looking, say, at storage and access of health information, what are those changes, do you think, and who should they be communicated to?
Well, in terms of access, that's a really important question because with COVID, companies are acquiring quite sensitive information about individuals' health potentially.
Mm-hmm.
All the recommendations from regulators is you keep this for the most limited time necessary or possible. So we've even seen guidance that would say, for instance, once you allow someone on site and they've passed through your checks, well, let's say you've taken their temperature and it's normal. That information should be deleted as soon as possible. Mm-hmm. Or if there's a time where it's accessible, let's say maybe you have it for a period of days, in that case, access should be limited to really those people who just need to know it. We've seen a lot of guidance in countries that would say only occupational health workers should look at that. or maybe the highest levels of your HR group. And those are the kind of principles being expressed in the guidance. So, and obviously, just one final point, security. The basic notion is in any data protection framework, you provide adequate or appropriate security, taking into account the risks that data represents or its disclosure would create. Considering the types of information companies are now collecting about their employees and others, security absolutely has to be top-notch, very robust. The laws don't specify any mandate any particular security measures, but you would want to be thinking very clearly about making sure the IT security is very, very good. Material or information is in hard copies, that's looked after properly. Things of that sort also need to be thought through.
Okay, and presumably now with many organisations who've advised their employees not to return to work till January, I think at the earliest, home working is clearly here to stay. So with regard to security, what are the main areas that employers need to concentrate on?
Yeah, well, it's thrown up really kind of unique issues, the whole home working phenomenon. There has been a little bit of guidance in relation to that. I think mostly what I've read is concerns about employees perhaps sharing company data off of platforms. There's a lot of third-party platforms which are being used to enhance communication out of the business. This can inadvertently lead to disclosures of data from within the company through an employee using these platforms with others. Another example might be using platforms and recording participation in the conversation. That's not something that normally happens in the work setting, but with these technologies, you can record things in real time. And so, you might get questions from staff, should we be recording conversations with customers because you have the facility to do it? Those are the kind of themes I see mostly coming up in relation to the home working scenario.
And what about information passing from the organisation or being taken, essentially being taken home? Are there specific sort of grey areas that?
That's a very good point. We're probably going to be in a position where, and have been in a position where, employees are taking much more information home and working remotely. I guess that would pose particular risks. You want to reinforce to your staff the fact that this information is often going to be business sensitive, confidential, to honor policies which require that information to be destroyed very securely. It's one thing to just go to your trash bin and throw very sensitive documents which you've printed on your printer at home without really giving a second thought to the fact that in a workplace might be shredded. And so I think that's probably another risk that many companies probably are overlooking, reinforcing to staff the fact that there are still security commitments and privacy commitments they need to honor, even though it's very easy to kind of get relaxed about those things when you're in your home because you don't think about them as much.
So in case of, God forbid, potential breaches there, do you think the ICO is going to take into account the fact that many organizations are formatting policy on the hoof?
Yeah, the indication from the ICO at least is that they're going to take a somewhat pragmatic approach to enforcement. And so I think they probably will. These are very unusual circumstances, and so we're dealing with just a new situation. So I think they will adopt a more pragmatic view, but to a point. That doesn't obviously allow people to do whatever they want. And I think, if you have really shoddy practices, there will be an enforcement and compliance risk you need to bear in mind. But for inadvertent oversights, which may occur because of the new situation we find ourselves in, I expect the ISO is probably not going to treat that as a priority for review and enforcement. That's just not going to be that's not their style historically.
Right. Okay. And we've talked about collecting customer and visitor details. What are the sorts of things, if you're sort of looking at your data protection compliance, what are the sort of things that you need to communicate to shareholders, and who are the shareholders now?
In terms of the business or?
Yes, in terms of the business. So as an HR person, what do you need to communicate if you're changing your policy or your compliance policy?
Right. Well, I mean, I think you have a few important stakeholders. First, HR, obviously, your own staff would need to know exactly what they should be doing,
Yeah.
and think very carefully about who within your staff is getting access to information about things like, who's ill, or
Yeah.
who has family members who are ill. Where they might have been if they have come to work, who they've been in association with. You have to be very guarded about who gets access to that information. It's not a free-for-all, obviously. And then your IT systems. You probably want to think about who is operating your IT systems during this COVID situation, and make sure that they're aware of the protections they need to apply to the IT system so they're not vulnerable. There's been a sort of spate of third-party hackers and efforts to penetrate corporate systems during this time, which have been reported on in the media. So that would be something you'd think about. And then just generally, I think you just need to remind staff, look, we all have a collective responsibility to both be safe and be mindful of the risks each of us presents to our coworkers. And also, we still have to maintain privacy and abide by the company's commitments to keeping information private. That might go down to even security people who, are at the front of entrance of a building, who would know perhaps if someone's coming through has a heightened temperature because a signal's set off. They'll get information that someone may be unwell. So you'd have to think like all the touch points that are being created now to new types of data because you're putting in place new systems, you're collecting new information. I think you'd want to think very carefully through all of those touch points and make sure that everyone's aware of the risks and what they should be doing.
Okay, and I know you're a global expert. Are there changes? Have there been sort of cross-jurisdictional changes, particularly in Europe, within the GDPR arena that people, I know quite a few of the people watching today work for global organizations, that they need to be aware of and take into account?
Yeah, well, the one thing that we've seen is the guidance is not consistent across the EU member states or even globally. Different privacy regulators view this a little bit differently. They view what employers can legitimately do differently. So for instance, in places like France or Belgium, they've taken a dimmer view of whether an employer should be collecting health information about employees through surveys or temperature checks. They kind of feel if that has to happen, and they're not really sure that's the best way to do it, they'd rather have employees volunteer this information. But if you're going to do it, it should be a health worker who's collecting this information. That employers should not be in the business of processing employee health data. Other markets tend to be a little more pragmatic. So what you'll find is what may be a safer approach or measure in one country may not be in another country. So you're really going to have to take a close look at the guidance that's being put out there in particular countries. The last I checked, there was like 250 to 300 COVID relating pieces of guidance across the EU. It's massive. And some regulators are just more prolific than others. So unfortunately, the situation's it's not easy to have a uniform approach across the EU. You have to take into account these variations we're seeing.
Okay, thank you. And in case of a second lockdown, obviously I'll have some dusty novels and cheese and artisan gin. As I suspect,
won't we all?
We'll be prepared. What might be some data protection implications of a second lockdown, and what are there areas of policy or practice that might be worth thinking about right now?
Well, I mean, I suppose as an employer, if people are just going to be working from home and not coming to the business, you'd have to think about what information you really need to know about your employees at that point. Maybe there's less need. It could reduce the risks because you wouldn't need to temperature check, ask them about their health because they wouldn't be showing up at work. Look, in all of this, the best thing to do is look at what the public health authorities are mandating and what the regulations they're putting out says. Unfortunately, for a lot of people listening today, they very often won't say what an employer should do. It's really not designed for that specifically. So if we go to another lockdown, we've gone through this before. Again, you'd want to be thinking about what information you're collecting from your employees while they're working remotely. Maybe it goes back to your point before, Elizabeth, about, if they're going to get access to information, do they present a risk to the company in having sloppy practices in relation to security? Things of that sort might need to be considered. But on the good side, you probably won't be worrying about contact tracing and sending out surveys and questionnaires, because people probably won't be showing up at work now unless it's some extreme circumstance necessitates it.
Okay, thank you. We've got some questions that have come in for you. In your view, Dan, is the ICO going to look rigorously and aggressively at the post-COVID data capture that companies have had to do in the last 4 months?
That's a really good question. If you're collecting COVID data and then deciding you're going to derive interesting insights from it, that I imagine would get a lot of attention and would not be a very good idea. I think what they're saying is, look, you may slip up in a few places during this period because your resources are stretched and you may have other priorities. But if you're intending to, let's say, collect health data on employees, and this may not be what the questions designed to or suggest, but if you were to use that data for a new purpose, I think you'd be really careful about that. That seems to be something I think a lot of regulators across the EU, including the ICO, would take a very dim view on, and so I wouldn't suggest that. Really the idea is, if you collect the least amount of information, you absolutely have to keep your workforce safe. And once you feel like you've accomplished that mission, get rid of the data. And so that should be the mantra. They talk about in the guidance being proportionate, fair, and reasonable. And so have that in the back of your mind in whatever measure you put in place and whatever you plan on doing.
Okay, thank you. Another question for you. Many of our clinical staff are now working from home and conducting virtual assessments. This has caused anxiety in terms of managing confidential conversations and informations. What advice can be provided to alleviate concerns regarding confidentiality and how to make hardware and content secure?
Yeah, that's a really interesting one. That probably would be an area where the ICO will just be aware that there may need to be a different mindset given to the information that people are having to collect at home, and some of which may be sensitive because of the nature of their jobs. I think your organization should think very seriously about, what kinds of IT are being used at home. Are you using laptops that are encrypted, provided by the employer rather than your home devices, which may not be suitably protected? Reinforcing policies as to the handling of data that you receive or your clinicians receive at home. Things like that. I think you'd be looking at technology solutions to help reinforce and protect the security of the data. But that's a hard one. I mean, we've seen in clinical trials in Europe, this is an area we follow, that there's been more remote sharing. It's not, regulators don't like it, but remote access to data, remote auditing of systems by people who perform audits of clinical trials for pharma companies. And it's, to an extent being allowed because that has to be the way it is at the moment. But as soon as you can get off of that arrangement and bring people back to work and have them work within these more protected systems, obviously that would be better. But unfortunately, there's no silver bullet for that problem at the moment. Yep. Yeah, that's a good question too. And it actually triggers a thought which I neglected to mention, which is there's a strong incentive to conduct what they're calling data protection impact assessments. The ICO really likes this concept, and if you're not familiar with it, it's basically if you're going to deploy a technology or perform an activity that's really novel and unusual for the organization, which might present privacy risks, you perform this DPIA. And so for a lot of the questions that we're that are being raised, it'd be worthwhile you performing this assessment. And the idea is you can demonstrate a deliberate and conscientious approach towards data protection. So I definitely suggest that. Now, do you have to have a third party do it? Not really seeing many organizations find the appetite for that. And I really don't think it's necessary in the bulk of circumstances. There may be unusual cases where you feel like you're not equipped to do it yourself, but the way the system's set up is organizations, even small and medium sized, should be able to perform these assessments. It's not rocket science. You know, you look at the privacy risks, then you consider the risk mitigation that you're able to apply, and then you document it. So I would probably hesitate, think really carefully at least about using third parties, because at the moment it just doesn't seem like there's a strong incentive for that, at least coming from regulators. Sure, no problem. Hmm. New risk areas. Wow, that's an interesting question. Uh, well, I mean, we're seeing a lot more attention. This is no longer a COVID question about, you know, international transfers of data. There was a recent case in which the European court struck down a framework that was used by many companies to send data to the US. So I expect regulators are going to spend a lot more time looking at transfer mechanisms. So if your business is transferring data to even another affiliate in another country, that might get a little bit more attention. If your business, and I'm not sure this would be relevant in an HR context, but if you're using artificial intelligence, you know, relying on computer algorithms to make decisions about employees, or even in recruitment contexts, that would probably be something I think privacy regulators are going to take a more active interest in. Those are at least two things I think to have on your radar. My pleasure. Thank you very much. Very good. Thank you very much. Bye-bye.
Thank you, Elizabeth. So as Elizabeth said, what I'm going to be mainly looking at today is the issues around COVID testing. We're going to have a look at contact tracing apps. Can you force employees to be tested? Issues around temperature taking, and then moving on to looking at how employers can share details of their colleagues and in what circumstances they can do that. So with regard to contact tracing apps, you may have heard this morning on the news that obviously they're not yet operational in the UK, and I think gathering what I could from the news this morning is that there seem to have been some setbacks, and nobody's quite sure when a contact tracing app will be in operation, or indeed what data it will collect and how it will work. The government seem to be pulling back on that. But there are private systems also in development. I know some of the big sort of business firms are trying to develop their own apps. And their use does give rise to a number of questions. And the first question I think they need to address is, do they actually need to use such apps? Obviously, there's a duty of care to protect the health and safety of employees, and there's a legitimate interest in business continuity and protecting the safety of employees for that reason. But I think employers, before they sort of consider using a tracing app with their employees and requiring employees to disclose that data to them, I think they really do need to consider is the use of that app and the collection of that data necessary to achieve that aim. You need to balance your interest in with regard to your duty of care, with regard to health and safety, and in business continuity, with the interests of the employees. And effectively that comes down to a balancing exercise between the safety issues of it for your workers and customers against the privacy issues here. And I think, you know, a big question is also, do you need to use an app to do contact tracing? You know, presumably you will know what employees you have in the workplace on a particular day, and so you wouldn't need an app to gather that sort of information. And another question is the app integral to the workplace strategy? Is it absolutely necessary to use an app, or can this data be gathered perhaps by other methods? And I think a very important question here is using an app in the workplace doesn't currently form part of the government guidance. So employers need to be quite careful about perhaps going further than the government guidance at the moment if they are going to collect data that might impinge on the privacy of their employees. Second main question is can employers require employees to download the app? The answer to this is probably yes, where the employees are provided with a business phone which belongs to the employer. It probably is reasonable for the employer to require that employees download certain apps onto a business phone. And indeed, employers will want they will want antiviral software and apps and things like that downloaded already, and possibly it would probably be possible for an employer to require a contact tracing app is downloaded to its phone. Probably also the case where employees use their own phones, and there is a bring your own device policy in place, because it's a fairly common term of those policies that the employer can require the employee to download certain apps. Although please, if you do have a bring your own device policy, check the wording of that, because quite often it requires the downloading of apps for certain purposes, such as antivirus software, and it may not cover that they would need to download a track and trace app. And otherwise, probably not. You probably couldn't force an employee to download the app to their own personal device unless the government advice on that changes and it becomes mandatory. The third question is having downloaded the app, can you then force your employees to use it? And my view on that is probably not. And the reason I say that is because the position of the ICO and the government is clearly that the use of apps must be voluntary. And I think it would be a brave employer who went against that advice, unless they had very, very good reasons for doing so. And I think if employers were to force employees to use an app, either by the threat of disciplinary proceedings or by saying they will be excluded from the workplace unless they do, that could give rise to perhaps concerns and enable the employees to bring a claim of constructive unfair dismissal if they were to resign in response to being forced to use the app. And I think it would be a brave employer who disciplined an employee who refused to use the apps in light of the ICOs and the government's position at the moment that they should be voluntary. Fourth question with regard to apps is can employers force employees to disclose notifications from the app? And for the same reasons that I gave previously, no, you probably can't force them to disclose a notification because the use is not likely to be mandatory. And could you require them to disclose the data and then discipline them if they don't? Basically what we're looking at here is the request to disclose the data that they've been in contact with a diagnosed COVID carrier, is that a reasonable instruction? And in looking at whether it's a reasonable instruction, you're going to need to consider a number of factors. There are sound reasons for requiring disclosure of notifications. You know, you've got the health and safety legal obligation to your employees, and you've got a legitimate interest of protecting the workforce and the business. But you can't just rely on that in saying it was a reasonable instruction to tell my employee to notify me of any contact. And you've got to balance the employee's interests about privacy. And this is a little bit different to requiring an employee to tell you perhaps that they've had a positive diagnosis, because we're not quite sure what information an app might reveal. For example, if an app revealed that 2 of your employees have been sharing a hotel on a Saturday night, that would be a significant intrusion into their privacy. And it might go further than simply a notification that they've been in contact with a carrier. So you do need to be very careful about the amount of data you're going to require them. If you require them to notify you of a contact, perhaps asking them to also notify you of the date and the time of that contact might be an intrusion, a significant intrusion into their privacy. And you also have to consider, is it reasonable to force workers to reveal notifications of contact when other measures might be sufficient to meet the demands on the employer? I mean, if they have had a contact, then they will may be required by the track and trace government system to self-isolate. So in that sort of scenario, is it really necessary for the employer to get involved? And we're by in an instance rather than temperature testing, which we'll come on to in a minute. Can you force employees to be tested? No, not generally. There's no general principle that an employer can force an employee to go into have a medical test done. It may be appropriate in some circumstances. For example, if you're a healthcare provider and your employee is going to be treating lots of high-risk patients, then it may be more reasonable in those circumstances. But no, there's no general onus on an employee to undergo a test if it's required by the employee. There is, in probably the majority of employment contracts, a contractual provision that employees will agree to consent by examinations by a doctor so that employers can gather medical evidence about capability issues such as long-term sickness. Now, it is possible, depending on the wording, that employers might be able to rely on that contractual provision to say that employees should submit to a COVID test, but we would have to be very careful about that wording, because the vast majority of the contractual provisions I've seen say that the employee will be examined by a doctor, and of course most COVID-19 tests aren't going to be administered by a doctor, and it would be a significant expense if you were to require a doctor to do each test. And similarly, there may be provisions regarding drug testing within a contract of employment, but again, it's unlikely that employers are going to be able to rely on them. The question is I think there probably is now going to be a change in the drafting of these contracts so that employees may be asked in the contract of employment, or will agree in the contract of employment, that they will submit themselves to sort of public health testing, but they're not in the majority of contracts at the moment. Another question you must also consider is that if you are going to require employees to be tested, and you are going to require those test results to be provided to you, then that will engage the Access to Medical Reports Act in 1998. And what that act requires, that you have to provide certain information to the employee, and that you have to get specific consent for that disclosure to you. It's quite a bureaucratic exercise. You do have to provide certain letters and forms to the employee in order to engage that. It might be the case that asking an employee to be tested could be a reasonable and lawful request, and I'll go back to the same sort of balancing exercise that we did with the contract tracing here. But a cautious approach would be advisable before you took any disciplinary action because of a refusal. You would really have to demonstrate that it was a reasonable request and it was absolutely necessary for your employees to submit to testing. Another issue to remember is that consent to processing data can't be relied on in an employment relationship. So the ICO have said that informed consent cannot be given between an employee and an employer, and so you have to rely on some other basis for processing the data. And as Dan said previously, that may now involve carrying out a DPIA, an impact assessment, so that you can now process that data. Luckily, nearly all employers do already process health data. You will keep sickness records of your employees' illnesses over the years. You probably will keep records of any severe allergies that they have. And so, to some degree, that should already be present within your policies, and they may just need an update rather than a significant review. One thing that nobody did foresee when we all wrote these policies in 2018 was that you might, one of the third parties to whom you might submit employee data. So third parties are typically payroll data you might give out. You might give it out to a pension provider. Nobody ever foresaw that we might have to give out data to a public health authority or to a track and trace organization. and you should ensure the policy is updated so that the third-party disclosures of employee data allow you to disclose those details to those organisations. With regard to temperature testing, the position is essentially the same as it is for a virus test, and you don't have the right to take a person's temperature without their consent. But again, there may be contractual terms within your contract of employment which provide that an employee should consent to that. And again, it might be a failure to follow a reasonable instruction if an employee did not consent. And in the case of temperature testing, where most of it will be done using an infrared thermometer on somebody's forehead, for example, it might be the case that it's a more reasonable instruction to an employee to require them to have their temperature taken than to go for a virus test, which is an invasive procedure. But again, it would be a brave employer who disciplined an employee for not taking a temperature test, and my view would be that alternatives such as requiring them to work from home or not attend the workplace are probably preferable to disciplinary action where we have this voluntary compliance regime by the government rather than any mandatory procedures. Now, I've said all this in the context of whether you can force people to take a test. And it may not be possible or appropriate to do that depending on the job role they're performing. But that doesn't mean that you can't request that tests are taken. And I think this would always be the preferable approach to start with. It's always better to get compliance than to force people to do things. Provided you can show that the request is reasonable and lawful, and provided you've done the review of your data protection issues and the impact assessment, there's absolutely no reason why employers shouldn't ask staff to take a test voluntarily if it's necessary. And you can say it's necessary just to protect the workforce within your business. And my experience of these type of things is that the vast majority of staff are likely to agree to that. You might get one or two who disagree, but probably 99% will agree to take a test in circumstances like that. Now, with regard to track and trace and having got your test results or being notified of a contact, can you share details of infected colleagues? And the guidance is that yes, it's entirely appropriate to share with employees that they might have been in contact with an infected person. And the government guidance specifically states that employers might need to keep staff informed about that. But both the government and the ICO state that you should avoid naming individuals if possible, and you should not provide more information than is necessary. The ICO guidance also states that a business shouldn't report a positive test to a track and trace scheme. So if you've carried out a test on an employee and that's come back positive, the current ICO guidance and the government guidance is that the onus isn't on the employer to report that to the scheme and that the scheme will automatically pick it up. I'm not convinced about that because I think that assumes that no private testing will take place, or if private testing does take place, that will automatically be reported into the track and trace system. I'm not aware if that is the case or not, but I think it does assume that in asking employers not to report positive tests, it assumes that they're all going to be captured within the government track and trace system. And the other piece of ICO guidance you should be aware about regarding positive tests that you're aware of is that if somebody phones you purporting to be from the track and trace system, the ICO guidance at the moment is that you should take measures to ensure that they are in fact from an official track and trace scheme, and do be aware of any potential data theft in these situations. So with regard to sharing details, obviously make sure the information is in accordance with your duties with regard to data collection and processing, but it is appropriate to disclose to colleagues the fact that one of the other colleagues has tested positive. You can disclose it to workers who may have been in contact with them, and I think it's sensible to disclose the time and the locations where the contact has occurred, and in fact it might be appropriate for the employer to carry out a little bit of tracing of their own accord in order to comply with their health and safety duties. But it's generally going to be inappropriate to disclose the identity of the individual who's been tested and probably whether or not they're actually symptomatic as opposed to being asymptomatic but a carrier. So I'll hand back over to Elizabeth at this point. I think they possibly could. The landlord probably has a duty towards the health and safety of its tenants. And I think it would probably be a matter of looking at your leases and seeing if your landlord can refuse entry to certain people. But the landlord will certainly be trying to comply with its duty to the health and safety of its tenants and the people using the common areas of its building. And I think it would be a matter of looking at your leases and seeing whether the landlord actually has those powers or not. That's something of a loaded question. Yes, I think we've seen the huge difficulties that the government have had in implementing a track and trace system. Having said that, I know that some of the big accountancy firms and the other business sort of support firms are developing these apps. Whether it might be better to try and hang on the coattails of one of those business support organisations and see if they can get something up and running as a more economic choice. That might be a better choice than trying to develop one yourself, given that it seems that the government are having enormous problems in developing a system, and it's been announced on the news this morning that there are further setbacks. Thank you.
Good morning. Yes, it's still morning. Good morning, everybody. This is a question that has become increasingly problematic over the last probably month or so, given that we are some 4 months plus into people working from home. That's likely to continue in the foreseeable future, either on a full-time or a part-time basis. But even before the COVID situation arose, we were often asked as safety practitioners, what is the definition of a home worker? We always gave 2 categories, and these categories actually linked very well with the HSE guidance as to home workers. The 2 categories is, first of all, someone who will work periodically from home, maybe 1 or 2 days a week or on a flexible basis, perhaps because of family arrangements, childcare issues, travel problems, or even if you just need the washing machine fixed. So that is one type of home worker. It's not in a contract of employment. It's an agreement between manager and employee. The second type of home worker is somebody who does work from home, either full-time or part of their time, and that is part of their contract of employment. So it's written down, it's agreed, that's their home is effectively in their workplace. And in those cases, the duty of care is much more extended, because the key question we are often asked is how far should we be going as an employer? Should we be making up a complete office for somebody working at home? Should we be spending lots of money on a computer desk and chair? What is it that's reasonable? And so we've had the two areas. Clearly, the second one needs a lot more time and attention. The duty of care is extended. And if you're going to have somebody working from home, it's reasonable for you to do some kind of home assessment to make sure that they have somewhere that they can work from home without detrimenting their health, safety and welfare, and that they have reasonable furniture, and that the furniture is actually provided so far as is reasonable again, and that's assessed not only in terms of ergonomic use, but being able to fit into the size and of the accommodation that the person's living. So that was before COVID. And whilst that all still applies, it was a game changer, as we all now know, because now anyone is working from home. And after the lockdown in March, when Boris Johnson said, go home, we have all sorts of people working from home on a full-time basis. We are seeing people coming back to work on a partial basis, perhaps in team A, team B, on a rotation. We are seeing some of our customers whom we've been doing copious amounts of COVID return to work risk assessments to help employers get back to work, help them find out how many people they can get back without making any significant adjustments, if they want to get somebody back, or a lot of people back, what they need to do to meet the law. But we're finding that people are coming back slowly, but many employers are saying to us, we're not going back anytime soon, certainly not before September. Many are saying not till the end of the year, to January, and of course, it's changing weekly with a game changer. So what is it that an employer is supposed to do reasonably? Under the Health and Safety at Work Act, we have a general duty of care to ensure, so far as is reasonably practicable, the health and safety and welfare at work of employees. So this, by default, because people are working from home, even though there is no contract of employment for it, it is reasonable for you to look at what people are doing and how they're doing, not only to do with their communication and mental health, which I know has been the topic of much debate over recent months, but on their physical aspects, the ergonomics. We are seeing a lot of people now beginning to report problems of neck ache, of backache, of wrist and arm and hand cramps, because their working conditions are not conducive to effective working. So when we're looking at what is reasonable, we effectively have to do a cost versus risk analysis. Whereas on one side we say, what's the chances of something going wrong, of someone being hurt? And then on the other side, what do we have to do to prevent that from happening or to minimize the chances? How much time is that going to take us? How much money is it going to take us? And we've seen some employers, one of our customers has spent over £2 million in a 2-week period to get everybody working from home. Others have spent 50, 60,000. Others have spent next to nothing or nothing at all. So what is it that is reasonable? We have specific objectives to make sure that what you do, your system of work is the way you do your job. Your plant is a very old-fashioned term that's in the Health and Safety at Work Act, which basically means the place that you work. So whether that's someone's kitchen table or whether it's their living room or even their bed, then you need to look at where they're working and is that sufficient for what they need. But there's lots of other areas of health and safety requirements there, which I won't go into because it would take too long, but perhaps for another time. We do have a blog that we've written that's on the front page of our website. You may wish to go to and have a look to find out more detail. In terms of specific regulations, we have the workplace regulations, health, safety, welfare regs, which contain specific requirements under regulation 11 for workstations and seating, which says that any workstation that you have has to be reasonable and a footrest, bizarrely, needs to be provided where it's requested by an employee. And your environment has to be suitable. Have you got sufficient lighting, heating, ventilation? The provision and use of work equipment regulations, which we call PURE, says your equipment has got to be suitable. and the health and safety display screen equipment regulations require assessments to be done. Now, I'm going to come to that in a moment about home worker assessments. It also requires that employees have periodic breaks from what they're doing. You can see from the photographs that I've added within this slide that there is a whole range of workstations that we've come across where people are working, whether you're working technically in a cupboard under the stairs, whether you're working in a spare bedroom if you're lucky enough to have that, or in your own office. We've even seen people working from an ironing board. Now, the good side of that is that it's at least height adjustable. You can move it up and down, but it doesn't really give that much space. And if you look at the photo here, that person is having to look significantly down, and that's going to bend their spine, bend their neck, and they're going to get severely uncomfortable after a period of time. In terms of the Health and Safety Executive guidance, they say that there is no increased risk from display screen equipment, that's DSE, for people who are working from home temporarily. Now, this was issued shortly after the COVID outbreak when everybody went home. They've updated their guidance, and I've given you the links. So if you wish to know more, you can go directly to those links. And the updated guidance says that if you are working from home on a longer term basis, the employer should provide reasonably the equipment that they may need to do their job. So you may need to look at, if they're using video conferencing, is there sufficient internet connection to enable that to happen? Is their phone system adequate? Do they have a reasonable computer to work on with perhaps a screen and a keyboard? If they're using a laptop, do they need a separate keyboard so they can at least move the screen to a suitable height so they're not constantly looking down? What is it that you have to do? The Health and Safety Executive also requires that you have regular contact to make sure that well-being is catered for. So I've got 5 more minutes. I can talk for England. In terms of home assessments, I will just go quickly on to doing a home assessment, what you should be doing as an employer. It would be reasonable, given the time frame, for you now to begin to look at a system where you can put together a simple self-assessment checklist. The Health and Safety Executive have got one. It's on these links. They haven't been modified for homework. They do give good pictures and guidance, but it doesn't look at what's going on at home. We have produced a little free download that you can use from looking at our link that's on this slide. We've uploaded it today. We require, we would require if we're doing the assessment, but you would also need to get a photograph of that person's home. Of course, that would come under data protection, under the GDPR regs, looking at the previous discussions we've had this morning, so that you can at least get a feel for where the person's sitting, what they're doing, and how they're working, and to have a dialogue as to what is suitable for them and what isn't. Very often, a non-ergonomic chair can be adapted, as this one is here for me, because this is my personal choice. I've used the cushion here. So I've got an uncomfortable chair with a beanbag, now makes it perfect for me. So simple changes are possible, but you won't find that out unless you ask the question. So you need to start off looking at some form of simple home assessment, ask the person to send in some photographs so you can get a feel, talk to any safety practitioners, safety people you have in your business. And if you don't have that access, then perhaps it's time to look at the services of a professional who can help you out. These can often be done over the phone quickly by looking at the photos, giving some simple guidance back as to what you should be doing, or even helping you with a working from home policy during COVID. I've got 5 more minutes, so I'll hand back to you in case there's any questions. I completely agree. chartered physiotherapists and ergonomists. They are the specialists in what they do, as are chartered safety practitioners. Well, this is one of my background specialities. I've written a number of books and publications for Kroner's and others on it. And physios know absolutely every part of how a body works. It may be a little bit of an expense if you have someone with an ergonomic problem, with back problems, but what is the cost of that compared to having somebody out of work for several weeks, several months, and potentially damaging their health? In terms of the legal requirement, you're unlikely to face a criminal prosecution for not assessing homeworking, but the risk here is civil liability, where someone will put in a compensation claim. And if you're looking at the time, trouble and cost of a compensation claim against getting in somebody like an ergonomist, a physiotherapist or a safety practitioner, it's a no-brainer. Oh, now that's an interesting one. Well, this is more of a data protection area. If they are, it depends on how sensitive the data is and what risk the company is prepared to take with that data, to be honest, because you can't rely on somebody chucking it in the bin and then that being exposed. So it would be good practice. And as part of the homeworking assessment, looking not only at the desk and the chair, but other needs. If that's needed and they're going to be working from home for a while, I would certainly suggest that's reasonable. Small shredders are not expensive. So when you're looking at the risk of breaking a data protection requirement against the risk of 30, 40 pounds for a shredder, whatever they cost, again, that's another no-brainer. Interesting question. You're looking at proactive or reactive measures. If you're looking at a case by case, you're shutting the gate after the horse has bolted, because by that time the person is suffering and uncomfortable, and it's going to take, you're dealing with soft tissue injury here. And anyone who's had a soft tissue injury, a torn tendon or ligament, will know that that can take a lot longer to heal than a simple fracture. So yes, you should definitely be following those up without doubt. In terms of lots of employees, that's why the self-assessment with the use of a photograph is the quickest, easiest, cheapest way to do it. Many years ago, I used to, and my team, my consultants, spent a lot of our time chasing around the country, visiting people's homes, when the health and safety executive had much more stringent requirements for home working. Checking out everything from the electrics to the fire escape to the first aid box, apart from the workstation equipment, to make sure that that home was reasonable. Now that clearly is not proportionate. The HSE recognised that and changed the guidance. But now they're saying if you're working on a long-term basis, you do need to provide the equipment, keep in touch with them. How do you know what kind of equipment they need and which is suitable, unless you do some kind of assessment? The logic would dictate really that you need to do an assessment to find out what's proportionate. And just giving somebody an allowance to go and buy a new chair down at IKEA or John Lewis or somewhere, that also won't cut the mustard. So okay. Thank you. Bye-bye.